Well, thank you, Marina.
For everyone that does not know us yet, I'll do just a short intro of myself. I'm a co-founder of the European Crypto Initiative, which is an advocacy group based in Brussels. We do work on all the topics related to crypto assets and blockchain, of course, and mostly with the regulators in Brussels. So we discussed all these very, very interesting topics in the past. You can follow us on social media to learn more about the newest events. But today we're focusing solely on what happened in France a few days ago. I think it was on the December 1st. There was a very, very interesting court case that Victor is going to tell us more about. But first, I would like to give you some minutes to introduce yourself, and thank you again for taking the time to join us.
Okay, thank you very much, Marina. My name is Victor Charpiat. I work with the Paris office of Kramer Levin, and my specialty is crypto regulation. So I've been working with crypto companies these past few years. At first, it was mostly centralized regulated entities. So we worked with a lot of crypto asset service providers in France in order to obtain registration with the local regulator. And after that, we have been following the creation of the MiCA regulation and also working with DeFi protocols and dedicating a lot of time to try to understand what should be DeFi regulation.
Thank you so much for this intro. And I think it's very important to say that France is playing a very important role in the whole crypto regulation in Europe as well. You've been one of the first ones to actually have your own crypto law, but at the same time, I think it also influenced a lot MiCA and some other regulations as well that we have adopted and finalized in Brussels. And you're always a step ahead, as you mentioned before. We learned and we read the ACPR and also the IMF papers, so the French regulators, the banking authority, and the securities market authority papers on DeFi. We have seen that you have also worked on a gaming law that might somehow and indirectly also influence the use of crypto assets. So it's always very interesting to hear more from France. And in this case, I think you and everyone in the space, we're working on these topics for years, but we do not have many court cases. And this is especially a very interesting one, the Platypus court case, which we have been talking about since December 1st, when you have also tweeted about, and there was a big discussion on Twitter or X and other social media. So maybe we can start with this. What was, in a way, the case about? Why are we talking about it so much? And in a way, who is it important for?
So as you said, France is one of the main countries for all crypto activities. It's also true for hacks of protocols. We have a lot of dedicated hackers in France. So those ones, they targeted a protocol called Platypus at the beginning of the year. So I'm not extremely familiar with that protocol, but what I understood, it's a protocol for minting stable coins. So essentially, people deposit assets, crypto assets, and they are allowed to mint a stable coin called USDP for an amount which is inferior to their collateral. And of course, there was a flaw in the code, as it's often the case for smart contracts. And the hackers found that flaw in the code, and they exploited it to issue around, I think, 8 or 9 millions in stable coins from the protocol, and then they sold it instantly to using a flash loan, also against other stable coins which were not related, like USDT, USDC. And doing so, they committed a lot of mistakes, like operational mistakes. They lost apparently part of the funds, and they were only able themselves to recover a few $100,000 in stable coins. and all that created a lot of problems for the Platypus protocol, of course. And the hackers were found quite quickly by the French police, because there were a lot of clues that they left behind, and some people online launched like on-chain investigations, and they managed to find their track quite fast. So the people were apprehended by the police, and they were sued before criminal courts for facts of essentially what we call in French escroquerie, which is basically fraud or swindle in English, which means obtaining funds using a fraudulent behavior. And so that was the criminal case against the hackers. It was supported in court by the lawyers of Platypus. And as a disclaimer, I must mention that I was not personally, or my firm, associated with that case. So we are only now commenting it because it's our common interest for all crypto lawyers and all people interested in crypto regulation. And so the beginning of the month, the Paris Criminal Court basically released the hackers. So they walked free. There were no charges that were confirmed against them. And one of these reasons, and that's why we're discussing it today, is that it seems that the judge accepted some form of the Cody's law theory, essentially considering that since there was a contractual relationship, or there would be a contractual relationship between the hackers and the protocols, because they used a flash loan, so according to the judge, a flash loan would be equal to a loan, so they couldn't be stealing the funds or swindling or like appropriating the funds using a fraudulent behavior, because as it's part of an agreement, then they only have a contractual relationship with the protocol, and contractual and criminal are not compatible. Basically, that seems to have been the reasoning of the judge. It's not 100% confirmed yet, but it's what's the most likely and the most consistent with the facts that we have. And finally, a few days ago, we learned that the prosecutor has filed an appeal in that case. So there will be a second trial with the appeal court, probably in next year. We cannot say when, but in general, in criminal cases, it takes like between 6 and 12 months. It's faster than in civil cases.
I think that this hack happened in February this year, so I would say that it was pretty fast, like the reaction of the French courts already, because yeah, that in a way partially, or as you said before, oral hearing was discussed in December. Can you tell us a little bit more where we are in the process and how much information do we even know? Can we read in a way a document coming out of the specific court, or how much information do we have?
So it's this is what is a bit tricky and problematic for us. We cannot read yet the final decision. The French criminal justice is not entirely based on written decisions. In most cases, part of the procedure is only made orally. So some decisions are not provided in writing unless people specifically ask for them. So in that case, we do not have yet the final written decision. Of course, we have asked for it. A lot of lawyers have asked for it. It could take a few more weeks before we have the final copy of that decision. But what we know is based on intermediary versions of that decisions that were circulated to the lawyers, so which should be quite close to the final one, and also like accounts from journalists and people who were in the court during the trial, and who just reproduced what the judge said, what the prosecutor said, and what the lawyers said. So we have like a very detailed accounts from the trial, and it confirms basically our understanding, which is that some kind of code is law theory was applied by the judge.
And let's focus on that one right now. So for the ones that might not know, or it's a new concept, code is law is basically something that has been used very much in the past and still continues to be used as something where we have a code that in many cases it's a blockchain code like Solidity, and in a way designed a smart contract where in a way the code would be the one that should be followed. So the code would be the one also acting as law in case there would be any kind of conflicts with interpretation of is there, for example, terms and conditions or something else might be forming an agreement. Or should we look into the code? And it's very interesting when it comes to hacks, because many times, most likely, different protocols will not design their smart contracts in a way that it would be easily for anyone to get funding out of the protocols. So in this case, this is why this court decision is so important for us. So what was the interpretation here with the French court?
So basically, the lawyers of the defendants, so of the hackers, did a great job at convincing the judge that there was an agreement. So since there was a smart contract and the hackers used a flash loan to exploit the smart contract, basically there was a contractual relationship between the hackers and the protocol based around a loan. So essentially, the hackers borrowed from the protocol the stable coins that they actually exploited. So they have a legal obligation, a contractual obligation to reimburse what they borrowed. And essentially, the judge said that the fact that they cannot be sentenced based on criminal law, existing criminal law at least, does not mean that there is no room for a civil case against them brought by Platypus or potentially victims of the hack, and based on that loan that would exist between them and the protocol. So this reasoning is basically, it looks like a very basic and just low-level understanding of how DeFi works, how smart contract works. It looks like a bit like a young person, like a child, would stop the reasoning at the first level of analysis, which is a smart contract. It's called a smart contract, so it must be a contract. So let's apply to the smart contract the rules that we have on the contractual agreements. It's a very basic way of reasoning, and it's the one that the judge chose for a reason that we cannot fully explain. One reason, of course, we can assume that the judge is not experienced enough with the underlying technology, that the people within the legal system, the judicial system in France, that are very used to smart contracts and DeFi are very not very numerous. But maybe that the main reason is that in France, and it's the case, I guess, in most systems, criminal law must not be interpreted broadly, must be interpreted restrictively. So this is a very strong point for the defendants and the hackers, which is that if there is no crime that fully fits the behaviors that they had, they cannot be sentenced based on other crimes that are similar but not quite the same in their definition. So we are in France, and France is a civil law system, which means that there is less room for precedent and case law, and there is more importance given to what is precisely written in the code of law and not the computer code. So that was the main reason, I would say.
There's so many interesting points that you mentioned, but maybe I would go to explore one by one. First, is there any kind of knowledge of anyone as a specialist coming into the court and maybe sharing more information about how smart contracts work,
Yeah.
how DeFi might be interesting from other software
So
developers?
there, as far as I know, there are experts within the police, the French police, which focus specifically on cyber crimes and also crypto-related crimes. So they claim in various interviews or press releases that there would be around 80 to 100 specialized policemen working on these cases. It's really questionable. I'm not sure that there are many more than like five to 10. But in this case, in general, when there is a complaint that is filed by something who was a victim of crypto theft or hack like this one, in general, it's routed through the legal system to a very specific office based in Paris, which deals with all matters of cyber criminality. And there are a few policemen who are assigned these cases, and these ones, they understand crypto quite well. Maybe they don't use crypto a lot themselves, but they understand it well enough. And in this case, generally, there is an expert who is appointed by the court, which is generally either a policeman or somebody from the police or somebody from a government authority like the cybersecurity authority. And that person is appointed by the court to explain to the court how it works at the technical level and to answer the questions of the court. And it's also possible that these experts, when they share their findings with the court, they do so in a way that creates some kind of confusion for the judge, or maybe they present it in a way that's more favorable to the hackers than it is to the protocols and the victims that are behind the protocol.
That's very interesting. And the other question that I would immediately have is, have they compared if there were any terms and conditions or any other terms that might be describing how this protocol would work, and if it would be in contrast with what we have seen or we could read from a smart contract? And maybe another question that might not be that related, but do you think that the interpretation might be different when it comes to a DeFi protocol versus a crypto as a service provider, a very highly regulated crypto as a service provider?
Yeah, for the second part of your question, I think the answer is yes. It could be very different with a centralized crypto asset service provider, because when you're dealing with a CASP, there is a legal entity which is providing a service, and that service is based on written agreements and not smart contracts, and that service is governed by applicable regulation. So in that case, in most cases, the judge doesn't have to understand how crypto works from a technical perspective, just has to apply basic rules that would apply in the same case for financial services. So the judge in that case doesn't need to understand fully how it works. There will be enough facts in general in those kind of cases to let the judge make up its mind on what was lost or obtained in a fraudulent way. So I think it's very different, and it will remain different. And the first part of your question was, what was it, by the way?
Sorry, yeah, if there were any terms and conditions that
no.
you might know.
As far as I know, there were not TNCs for that protocol, and it's not, as far as I know, it's not something that was in the discussion before the judge. So probably not, which is very interesting because there are a few decentralized applications based on smart contracts where you have actual terms and conditions that are available on the website, and when you use the smart contracts, you have to expressly accept the terms and conditions, and the terms and conditions clearly say that a contract will be formed if you interact with the smart contract. So in that case, it's much more clear that there is a contract. But in the case of Platypus and in the case of most DeFi protocols, there are TNCs, which are templates, but they govern more like the use of the website and the front end than the use of the protocol itself. And in most cases, as far as I know, those TNCs don't say that an agreement is created, is formed anytime somebody interacts with the smart contract. It's not what they say. They're mainly focused on risk disclaimers and saying basically that whoever wrote the code and created the front end is not liable for anything that happens after that. So it's not something. It's something that we might discuss because this case has been appealed. So there will be a second trial next year. So maybe the question of the terms and conditions will be discussed. It could be used as an argument. But the main, basically, maybe it's not exactly your question, but it's a personal point. If we go down the contractual route, so if we really start to study before a court the contractual argument, there will be other consequences, and the judge before the appeal court will have to be much more specific and much more relevant in its arguments than the judge before the first court, the lower court was, because there are very obvious questions that were not answered by the first judge. And essentially, just if there was an agreement, was the agreement even valid? Was it enforceable? So those are very basic questions that were, as far as I know, completely missed by the first judge. And this is why the decision looks truly quite unfair from the perspective of both the victim, which is Platypus or the people using Platypus, and from the perspective of the common interest of the DeFi ecosystem.
There's again a brilliant point there. So one is, what is the practice at the moment? As you said, we have different options, and of course different protocols and platforms, smart contracts, they are designed in a different way when it comes to the combination of a smart contract and also terms and conditions being there, or maybe we even went into some kind of a combination when it comes to, let's say, hashing terms and conditions in a smart contract. So it would be really shown that is kind of a brought together even from like a technical point of view, or Ricardian contracts as we call them, etc. So I think this has been discussed really for a long time, for many years, and we've seen a lot of development and also experimentation. I'm not sure if you would like to comment a little bit on that in general.
I think the issue with smart contracts is it's not that they are not contracts. I think they can be contracts in some way, or they can be the underlying base of a contract that uses the smart contract as a tool, as an instrument to materialize itself. I think the issue is that smart contracts do not present themselves as contracts that are understandable by either the people that would enter into them or by a judge. It's one thing to have all the terms of a smart contract that can be consulted on the blockchain, but first, it's not that easy. It's not that obvious. In some cases, apparently, the code that is presented on GitHub as the code of one protocol is not the same as the code that is actually deployed. Plus, there is the question of the transformation of the code between the code that is written and the code that is actually on the blockchain, because as far as I know, it's transformed to bytecode. So there is like this compilation and decompilation that happens. Plus, we cannot reasonably expect general people like consumers or even professionals to check and verify every term of a smart contract before interacting with the smart contract. It's not feasible. So it's not an argument, I think, that we can bring before a judge saying that whatever is written in the smart contract is the law between the parties and is the exact content of the agreement. At some point, we need to take into account what a contract truly is. A contract is, I'm not sure how exactly you say it in English, it's the reunion of wills to create a transaction. So the intent of the parties is what truly matters. Did they want to enter into this transaction? So in that case, they wanted to enter into a certain transaction, but it turns out that the transaction is different because the code was written in a way that something that they did not anticipate, they did not expect, based on their understanding and their knowledge. The outcome should be different. I think we cannot build an economy or a crypto ecosystem around a prerequisite for every person that interacts with a smart contract to have performed an entire due diligence on the content of the smart contract, and then these people would be responsible for anything that happens to the smart contract. If there is a hack, if there is an exploit, if they lose their funds, there would not be any kind of legal backup or legal theory that would enable them to recover part of the fund. So this is not something that works in my opinion.
So for everyone that's listening, or for the ones that just joined, I'm just going to do a short recap. We're discussing the Platypus case, and we were just discussing the part when we, in a way, went into the definition of an agreement and how important this is for this case. And I think it really, really goes in a core of what the law is and what a contractual law is. How do we define it? How it is, or it might be different in each member state. So it's really hard to talk about a European contractual law. At the same time, it is something that has been with us for thousands of years, from the Roman law on, and it is something that, of course, lawyers are very much, we're working on and opinionated on. But when it comes to the digital, in a way, version of it, or even worse, the one on blockchain that has their own characteristics, there might be still questions, and especially in court cases like this. We'll discuss another 15 minutes, and then I'll leave the last 15 minutes for questions. I see that we have already some in a chat, and I hope we'll be able to respond to all of them. So going back to what a contract is, an agreement, I think important for us as we work on the Data Act, as we were discussing in our social media and in general, it was pretty important for the whole blockchain ecosystem, because one article there was talking about smart contracts. The first thing that we saw there was, in a way, the problem of the definition. So what is a smart contract? Is it a digital contract, similarly to how we call smart devices or IoT devices? Or would that be a smart contract in a very strict term, in a way how we use it in the blockchain space? And that was pretty interesting, because it doesn't have anything to do directly with a contractual law, because the Data Act is really just, in a way, regulating data, non-private data, mostly used for use cases such as I mentioned before, smart devices, so the data that is coming from IoT devices, etc., to, in a way, facilitate the creation of markets around data. And the part that was really interesting there was the discussion about interoperability. So we, in a way, the idea was we should make this technology interoperable, so the data would really be able to, in a way, be transferred from one party to the other, and we would really be able to create markets in this case. But that really small article in a whole regulation has opened so many questions. As I said before, first, what is a smart contract in the sense of that regulation? And then the other part was all this design prerequisites that in a way the Data Act defined in a way that it should be mutable, so it cannot be immutable, which sometimes happens in the blockchain space, or how and in which case there is an access, and of course the question is from which party, etc. So how do we define smart contracts? And this case, I think it might be interesting now when it comes to those two different procedures, a criminal one and of course a civil one. There's a question about how do we interpret contracts and agreements, but also very much for cybersecurity point of view, maybe when it comes to data, there would be certain obligations going forward. There will be a lot of obligations, I feel, when it comes to some kind of a software that until now we have not thought about so much.
Yeah, I completely agree with you. It makes, I think, much more sense to look at smart contracts from the cybersecurity perspective than from the contractual and civil law perspective. Smart contracts are computer programs, software programs, and above all, we should look at them with the legal perspective by taking into account the fact that they are computer programs. So they should not be treated differently just because they're immutable or they self-execute, which is maybe not the exact reality, because they're only executing themselves when transactions interact with them. So it makes more sense to look at them from that perspective of what would be the role of the people writing the smart contracts. Do they have a liability in relation with their maintenance, with the quality of the code, with its potential review? And of course, with smart contracts, the main issue is the fact that they are in some cases immutable and that they cannot be removed once they are deployed in the blockchain. And this is something that is hard to understand for regulators. The fact that something will exist forever once it's deployed and cannot be modified anymore. So it's obviously a very complicated and very broad topic. But again, it's certain from my perspective that by calling them smart contracts, we have misled probably an entire generation of lawyers, judges, and prosecutors, and also academics, because I think they have their responsibility in that. And we have mistaken the automated execution with automated agreements, which should be, I think, two really different things.
That's actually a brilliant quote. I think that at least in the beginning, there was a lot of lawyers were drawn to this space because of how we named it at the beginning,
Yes.
smart contracts. So that was done. We have some lawyers in this space now. Maybe it's time to be more concrete with the naming and maybe change the naming. I totally agree with you. We are facing this daily when specific words are in a way meant in a specific way. There is no yet legal definition of it. And this is in a way what we are seeing every day with our work. Some words that have been used in such a novel way, I would say, yeah, for the last few years, not more, only and created by the community, mostly from the tech perspective, now are turning into the legal terms, which might have a totally different meaning. Similarly, I know we discussed that before, but for example, an NFT in a way how the community is using versus an NFT in Mika is something completely different. And in this case, smart contracts are something that is so important that I think it's also important for us to name them and important for us to in a way describe them and define them properly.
Yeah.
And in a way, this case might be an opportunity for us to do so, at least in Europe.
Yeah, and I think there is another very interesting example in DeFi. It's the flash loan. In the Platypus case, it's very clear that the flash loan was understood by the judge as a loan and treated as a loan. So basically, the judge said to the hackers, you borrowed crypto from that protocol, so you might not be liable in accordance with criminal law, but you are liable in accordance with contract law because you made a loan. But a flash loan is not a loan, it's something different. I checked in that context the documentation on the Aave website, which was one of the first protocols to implement flash loans, and it clearly says that a flash loan is not something that's comparable to anything else that we have in the traditional financial system or even the traditional economy. It's something different. It cannot be compared. So the most basic way to describe it, to facilitate understanding, is by calling it a flash loan because it looks like a loan, but it's executed immediately in one transaction. But this is like a marketing approach. It's a simplification to facilitate like just the general concept that is complicated. But the problem is that lawyers and judges are taking it literally and giving legal consequences and creating legal conclusions around facts and theories that are that do not really correspond to the reality, the underlying reality. So this is an issue that we have, and I think we will continue to have it for quite a long time until there are like very precise and specific pieces of work, articles, legislation that clarify that those are different things.
Maybe we should do a wiki on what is what for all the lawyers and regulators. I think that would be very useful. And this is in a way also in line with sometimes when we discuss and we see this in many different proposals when we think about the same risks and same regulation, but that is exactly a case. There might be a different risk and also the response should be different, but then we need to solve this problem with naming for sure. Another very, I think, important topic is there might be some audience that is based in the US. You mentioned that before. Maybe just very shortly, what is the difference and what would be the effect of such a court case in France and how that might be different from the US in general, and maybe a perspective on the EU. So of course, as I mentioned before, we all have different legal systems in member states, and that might be something that our courts will probably look into that, but it doesn't really make precedence for the whole European Union.
So first, as you say, it's entirely based on local law, so it's not unified in any way. I don't think it will be unified before a few years. Plus, this is not financial regulation, at least for now. Contracts law is something that was always very specific to the jurisdictions. It's not harmonized at the EU level. So the only solution that we could have would be that there is some kind of international unification, which is not binding, like the works done by some working groups at the UN level, or for like international law geeks, some working groups in The Hague, in the Netherlands, which will bring together lawyers and law professors from many countries and try to find some kind of consensus around the civil law principles. But it will take years. And in the US, what's really interesting is that there has been already a case of criminal trial against somebody who hacked a DeFi protocol. It's the well-known Mango case with the hacker called Avraham Eisenberg. And what's really interesting, it's a quite similar case of exploit of a protocol. In that case, it was not directly the code of the protocol which was exploited. It was an economic aspect of the protocol. So basically exploiting the way the oracle understands the price of the token which are used as collateral to mint stablecoins and borrow stablecoins. And what's really interesting is that this hacker is not being tried for theft or swindle or something similar. Is being tried for market manipulation because the CFTC has considered, with a lot of interpretation, of course, because we would not have the same in France, that there was a commodity, the underlying was a commodity, and the person manipulated a derivative based on a commodity, or just a derivative, I'm not sure. And by doing so, the crime is the manipulation of the market price of the commodity, but is not the fact of having exploited the protocol. So it shows also that even US law, which we understand from Europe, is way ahead in terms of enforcement and the severity of the enforcement. Even US law does not seem really confident with with protocol acts and the fact that a court could sentence somebody just for having used a protocol and hacked the protocol. So maybe it shows that the law needs to change, or maybe it shows that the prosecutors and the judges are just not they don't understand well enough how it works in order to be able to apply existing law to this kind of behaviors. I think personally that there is no need to change criminal law every time we have a technological innovation. We had the internet in the past, and we created specific crimes based on the use of the internet. But for the rest, there are the crimes that can use the internet, but their definition has not changed. It's just that they're applied to the behaviors that are based on the internet without need for like a change or an update in the legislation. And I think it will be the same for AI in the future. So I think it's more a matter of interpretation from the judges and just basic legal reasoning. So they have the toolbox. It's what we learn when we study the philosophy of law, etc. in college. They have a toolbox. The judge has a toolbox which is based on definitions, precedents, etc. And the use of these tools is up to the judge. And the judge can reach many conclusions which will all be legally correct using these tools. So now the judge just needs to find the right arguments to protect society as a whole, protect the victims, and protect, in a way, the crypto ecosystem by finding the hackers guilty of these basic crimes, which would be, in that case, theft, I think.
That's actually a brilliant point, and I might argue that we need both. We need more education, and there might also need to be maybe some adjustments or new laws, at least the ones that are directly meant for specific technologies, like not the criminal law, of course, but more like cyber security, etc., which is already happening in a way in Europe. And I think what was also interesting, if we in a way go in the last part of our discussion, the difference between a criminal case, the criminal procedure, and the civil procedure. I think maybe for also the non-lawyers that might be interesting. So there was a criminal procedure, if I understood, and that was the outcome of it. But then we still have the civil law one.
Yeah, I'm not sure that there is currently a civil law case against the hackers. And there might be one in the future, of course, because basically the judge said the protocol can now sue you before a civil court. But this is, I think, even more complicated. And I'm quite confident that a judge before the appeal court can sentence the hackers because there are legal reasonings that work. But if there was a civil case, I think it's not the same, because the problem is a civil case is one person against another, while a criminal case is society represented by the prosecutor against one person. If we have a civil case for Platypus, and it's the same, I think, for many DeFi hacks, who is bringing the case? Is it the Platypus company? But what does this company actually do? They created the protocol, they operate the front end, they wrote the smart contracts, but basically they're supposed to be a decentralized protocol. They present themselves as a DAO, so they don't own the funds that were exploited. So this is the main problem with relying on civil law or on civil cases to obtain some kind of retribution or reparation. I think it does not hold, it will not work in front of a civil court, because the civil court will very easily rule that the Platypus company is not the beneficiary of the funds that were exploited. So if in any case there was a loan between the protocol and the hackers, it's not a loan that was made by the Platypus company, or that the Platypus company was in any kind of contractual relationship with the protocol, like acting as an agent of the protocol. So it does not really work. It would work if the smart contract was absolutely like owned by a DAO, and the DAO would sue the hackers for the reimbursement of the loan. But again, it's not easy, because it would mean that when people deposit crypto assets into the protocol, they don't own these crypto assets anymore, and the protocol owns the crypto assets. So it doesn't completely make sense either. And the last solution would be to consider that the victims, in the case of a civil case, would be the people who deposited into the smart contract. But even then, it does not completely make sense, because one could argue that they just lent crypto assets to the smart contract and to the protocol, so they don't have a direct relationship with the hackers. So I think we really don't want to go before civil courts with this kind of case. And in any case, the probability to recover any of the funds is very low, because in that specific case, the hackers lost like 90% of it. So they don't even have assets that we can recover before a civil court. They are virtually like penniless. They have very limited assets themselves. So what we would recover before a civil court is so limited that, from my perspective, the only retribution that we can have for this fraudulent behavior, which was the hack of the protocol, is a criminal sentence. It's not a court decision to reimburse what they borrowed from the protocol.
Thank you so much for these answers. We have another 10 minutes, and I see that we have a question here. So I would go to that one now. I want to say that we're not giving any legal advice here, although we have a lawyer here responding to our questions. So feel free, Victor, to respond as you would like to, or even no response. We'll definitely find a more diplomatic response to the question. But the question is, so if a DeFi protocol has front ends, they should include terms and conditions to cover these issues.
This is one of the most relevant questions that we can think of. There is a distinction between the smart contracts and the front end. This is very clear. Even from us, users of DeFi, it's very clear. And for the regulators now, it's also quite clear. They will tend to apply at the front end level most of the obligations that they would apply in the context of centralized financial intermediaries. So it makes more sense to have terms and conditions at the level of the front end. This would be, I think, this will be in the future the best practice. There are already some protocols which are much more centralized than the protocols that we have, that we had these past few years, which say in their terms and conditions that a contract is formed anytime a person uses the front end to interact with the smart contract. So I think the terms and conditions at the front end level are quite important, but still the trick is whether or not there is an agreement that is formed, and if an agreement is formed, with whom the agreement is formed. Because if an agreement is formed with the protocol, with quotation marks, or with the DAO, we have an issue, like a very specific issue, which is that to have a contract, you need two parties. You can have unilateral contracts in some cases, but it's not the most common. And you need to be able to identify both parties, and you cannot have a contract with a person that you cannot identify. And the protocol itself is not a person. The DAO itself is still not a person. So it's not easy to consider that there are contracts, and I don't have a direct solution for it. I think that for the protocol to use put at the forefront terms and conditions, it's more a question of liability for the front end itself, with risk disclaimers, with indications that people should not use the protocol unless they understand how it works, unless they have studied the smart contract itself, etc. It's more a matter of protecting the front end, not really the protocol.
That is very interesting, because I would go back to the case that I mentioned before, the Data Act. In this case, there was also some requirements for again, smart contracts to be designed in a specific way, but there's always this opportunity and possibility for the front end, from the application, from any kind of a website that we interact with, to just disconnect with a specific smart contract and reconnect to another one. So basically redesign the smart contract from the beginning if the front end wish to offer another backend service to whatever application or the use case there is. And I think that's also very interesting, because there's like a lot of possibilities that might not be in a way visible from the beginning. So there are no questions anymore. If anyone else has any questions, please type them in. But I would like to finish with the last question, looking into the future. So what do you see 2024 being the most important or interesting event, and maybe even in the light of this court case, or DeFi regulation in general, or your work when of course you work with crypto companies in France?
Yeah, I think I really have 2 points, and they're quite personal, so I'm not speaking on behalf of anybody, not on behalf of the French ecosystem. It's just my views. I think that with DeFi in general, we have a problem which is clear, which has been clear in the past 2 years, which is that we are not able, as a community, to reach a consensus amongst ourselves to suggest to regulators a way forward for the regulation of DeFi. There is no consensus, I think, within the crypto ecosystem. There was proposals, notably from SBF right before FTX fell, basically saying that front ends should be responsible for everything, so that protocols and their developers are not responsible for anything. It's still something that probably will be the outcome if nothing else happens. It might not be the best outcome, and also it would change DeFi as we know it. So my concern and my hope for the next year is that the DeFi community as a whole finds a consensus on a way of regulation which is both acceptable for regulators, and provide some protection for the users, some kind of responsibility and liability from the people who operate the protocols, but still allows us to continue using DeFi as we know it, which is open, borderless, without KYC. So this is the big challenge for next year. And the second point that I will really be encouraging next year is decentralized front ends. We need decentralized front ends. It's probably the answer for most of our problems that we have right now. If we have generalized decentralized front ends for all the major applications, I think DeFi truly becomes more decentralized and more resilient to regulation. But again, it depends on what our goal is. Is it to protect DeFi from regulation, or is it to protect everybody using DeFi from losing anything? So it really depends.
Thank you so much for this. We know that those decentralized front ends are something that some projects are already working on. It's been a debate for some time, but it would truly revolutionize a part of how we are using those applications for sure. Thank you so much for joining us for this hour. We learned a lot, and it was all put together. You don't need to scroll back to Twitter or read any kind of media post, etc. It's all in this video, and it was basically like a brilliant podcast. So thank you so much, Victor, for all your knowledge, and we're very much looking forward also to learn more about the case when the whole part will be published and we can read the written outcome. Thank you so much.
Thank you, Marina. Thank you, everybody.
Thank you for joining us.
Yeah. Goodbye.